Hey guys, it's Dion with My Fair Lawyer. Today, let's talk about evictions. With the rising cost of housing and the rental market has gone crazy, a lot of people unfortunately are facing evictions. Now today, in this video, I want to cover the eviction process and not too much the legal defenses. I can do that in another video. I just don't want to make it too confusing. And when I refer to the law, guys, I'm going to refer to Florida law. So in your jurisdiction, in your state, you just Google the laws in your state. Back in the day, we had to go to a law library to get the laws. Now you can just simply Google the law, okay? Now, when I talk about the laws being pro-landlord or pro-tenant, in Florida, the law is pro-landlord, which means the laws are designed pro-businessman. The laws are designed more in the landlord's favor. Now, when I talk about the laws being more pro-tenant, I'm talking about the laws for similar like in the Virgin Islands where I'm from. The laws are more in favor of the tenant. So the tenant has, a little bit more flexibility than the landlords do in the Virgin Islands. But for the sake of this video, when I refer to the law, I'm talking about Florida law, okay? Now, before we go into the eviction process, let's talk about the different types of tenancies there are. There's the week-to-week tenancy, and it's pretty self-explanatory. Then there's the month-to-month. If you're looking for something short-term, you're going to want a week-to-week or a month-to-month tenancy. But if you're looking for something more long-term, the goal is to get an annual tenancy, a one-year tenancy. Now, once you have that contract in place, you definitely want to make sure that you have that contract in your hand. Now, a lot of my clients, unfortunately, they'll sign the lease, and the landlord will sign the lease, and then the landlord will walk away and say, I'm going to make you a copy of the lease agreement. But some of these landlords are shady. It's just unfortunate. But the landlord will get you to sign, they'll sign, and then they'll walk away and say, I'll go make a copy, and they never make that copy. And then you spend the rest of the year asking for your copy of your lease, and you never get it. Guess what? If you don't have that written lease contract, you're not a one-year tenancy holder, okay? It means you will automatically fall to a month-to-month tenancy. So having a copy of that lease agreement is significant. And I tell clients all the time, before you leave that signing of that contract, you'd want to take a picture of every page of that lease agreement. Then the landlord can go off and make a copy, okay? Get your phone out, take a picture of each page before you let that lease out of your sight. Another thing, it is not a lease agreement if it's only your signature on there. There needs to be the landlord's signature and your signature. Without one, then there's no agreement, all right? You just have a proposal. It's not a lease agreement until both parties' signatures appear on that document. Now let's get into it. In Florida, before you can evict someone, because landlords will just threaten to come and kick people out, and that can't happen. That's an illegal eviction. The landlord must issue a 3-day notice to vacate. It says your name on there, the landlord's name is on there, the landlord's contact information is on there, and the amount of money that you owe is also on this 3-day notice to vacate. It can be posted on your door, it can be given to you in your hand. Now that 3-day notice to vacate does not have to be notarized. The landlord gives you that 3-day notice. You have 3 business days. It doesn't include weekends or holidays. You have 3 business days to produce that money or leave and avoid an eviction. Let's give you an example. If you're served with a 3-day notice on Monday, when I say served, you're given a 3-day notice on Monday. You have Tuesday, Wednesday, and Thursday to give the landlord that money or leave. If you don't, Friday, the landlord can go into the courthouse and file that eviction. Now, when I say file the eviction, that means the landlord goes into the courthouse, hands the clerk the paperwork, the complaint, and files it. Now, from the moment the landlord files that eviction in court, your life changes forever, because that filing will now appear on your credit report. Under the public record section, you have the credit financial portion of your credit report, and then you have the public record section. Well, that eviction will appear there for the rest of your life. It never goes away. And that's why I tell my clients, try to avoid an eviction at all costs. All right, so now let's say the eviction is filed, you're now served with a copy of the eviction. Now, service in Florida, it can be posted on your door, it can be given to you in person, all right? Now, Once you've been served with that eviction, you have 5 business days to file your answer. Now, your answer is your side of the story. So you're filing your answer with the court. Whether you have the rent money or not, I tell my clients, file an answer, because you know what? If you have no rent money, at least you're buying time. The wheels of justice are still turning, but you're just slowing the wheels down. Now, when your answer, clients always ask, well, how do I file an answer? You look at the complaint, the landlord's complaint. It's going to be paragraphs, and it's going to have numbers. Paragraph number 1, there was a lease agreement between so-and-so and John Doe. Yes, you in your answer, you write number 1, admit. Number 2, tenant owes the amount of $4,000. Well, you feel you only owe $2,000. So you will write deny. I only owe $2,000. And then paragraph 3 and so forth. And yeah, that's your answer. Then you're going to file your answer, like I said, within 5 business days. Doesn't include weekends, doesn't include holidays. So if you're served on Monday, you have to file that answer. You have Tuesday, Wednesday, Thursday, Friday. That following Monday, you have to have your answer in the courthouse along with your rent money. But like I said, if you don't have your rent money, and most people don't, that's the reason why they're being evicted in the first place. If you don't have that money, you file that answer anyway. And if there's a discrepancy as to how much rent is owed, then you need to file along with that answer. You want to file a motion to determine rent, where the judge will make a determination as to how much rent is owed. Now, listen carefully. You are to pay the rent to the court from the moment an eviction is served on you. Do not pay the landlord anymore. You pay your rent going forward at that courthouse. If you're paying the landlord on the side, the court does not know it, and you are going to be evicted. Follow the instructions. Pay the rent to the clerk at the courthouse. Now, again, for the process, so we can get this conversation to proceed with the eviction. You've been served, you filed your answer, now there's a hearing. The hearing is going to be either by Zoom, virtually, or it's going to be in person, and you have to appear for your hearing. The landlord's going to get to speak first, they're going to tell their side of the story, and then you get to give your legal defenses. Now, when you hear lawyers say legal defenses for purposes of eviction, a court cannot take the fact that you lost your job, or you got sick, or you were hospitalized. None of those are legal defenses. Those are all emotional arguments. A legal defense is where the landlord failed to do something, all right? The landlord failed to repair the roof, but you still are responsible to pay the rent. Clients get that mixed up a lot. They mix up the two. Because the landlord didn't do A, I'm not paying my rent. Because the landlord is a slumlord, I'm not paying my rent. Don't fall into that trap. I tell my clients all the time, no matter what's happening, pay your rent. You know why? Because once you stop paying your rent, you are in breach of your responsibilities as a tenant, and you have breached the lease agreement. And once you've breached the lease agreement, the landlord has a right to file an eviction against you. So never stop paying the rent, okay? Pay the rent. And what I tell clients to do is pay the rent and sue the landlord in small claims court. That's how you get around this, okay? You get results and you still get justice, all right? So this is what you do. Instead of, for your legal defenses now, hopefully you won't be in eviction court, but you will be in small claims court, and you will be able to ask the court there in small claims for an abatement of the rent. Now let's back up a little bit, because I can see I'm confusing a couple of you. In eviction court, we're just going to go through the whole eviction scenario as though you didn't pay your rent and you've ended up here for eviction court. And then I'm going to just sidetrack and go back over to small claims for those of us who did not get an eviction because we paid the rent no matter what. So say you didn't listen to Dion and you didn't pay your rent, and now you're being evicted. You've told the court, the landlord failed to fix something, and you're pretty upset, and you stop paying the rent because of it. Anyway, you lose your case. The eviction is granted. The court is then going to issue what's called a 24-hour notice to vacate. The 24-hour notice to vacate is where the sheriff or the law enforcement officer comes out. They tell you you have 24 hours to get all your stuff out. If you don't get it out, too bad, so sad, it's over. Now, you pack up all your stuff. The following day comes, the sheriff pulls up. They issue the writ of possession, which basically gives the landlord the right to get the property back from you. And the landlord has a decision to make. Is he going to take your stuff out of the unit and throw it on the sidewalk and everybody fends for himself? Or is he going to put a padlock on the unit and leave your stuff inside, and he could sell it, do whatever he wants to do with it? That's the determination that the landlord has on that day. Now, can't tell you how many clients wait until that very last day and the writ is served, and now they want to be able to go back inside and get their sentimentals, get their, their watch, their passport, whatever. The landlord doesn't have to open the door for you ever again. It's over. It's really, you're at the landlord's mercy. The sheriff can't make him open the door, him or her open the door for you again. That's why it's so important to really pack up. Once that 24-hour notice comes through, pack up and be ready to go. Have your stuff out of there in that 24-hour period, because once that door is locked, it's locked and you're at the landlord's mercy. All right? Your visa, passport, your mom's jewelry, none of it, you do not get it back, and the landlord can keep it, sell it, do whatever they want to do with it. So after that writ is the last. You get 3 visits in Florida from the sheriff. The first visit is to serve you the eviction. The second visit is a 24-hour notice. And the third visit is the writ of possession. And then it's all done. Now, like I said, I'm going to address the legal defenses to the eviction and what you can and cannot do in more detail in another video. But for the sake of this, video, let's see what happens to the client who does listen to Dion and has paid the rent, all right? She's not facing eviction. She decides to sue the landlord instead. So she's paid her rent religiously. The place sucks, but she's paid her rent. Now she sued the landlord in small claims court. The landlord is served. The landlord has 20 days to respond to the complaint, and now they are appearing either virtually or in court. The tenant gets the first right to speak now. They're the plaintiff. The landlord is the defendant in this scenario. In this scenario now, the tenant gets to show the exhibits, all the videos, all the photographs, maybe estimates from contractors as to what's going on with the place, that there's a hole in the ceiling, and it's been there, since Hurricane Irma. Now, I say all this, but it's super important that everything you do with the landlord is documented, whether it's a text message or an email. You've got to prove that the landlord had notice of all these issues, these repair issues, and ignored you. All right? So you want to show text message after text message or email after email where you're begging and pleading, my children are getting wet, there's mold in the entire unit. You've got to prove it. You got to prove the landlord knew. Because say you don't document any conversation with the landlord, you just talk on the phone. Guess what the landlord's going to say when they get to court? They're going to say, Your Honor, I didn't know that the roof was leaking. She never told me. Don't you think I would have fixed that, Your Honor? Don't risk it. Everything, document, document, document. If it's a writing, then you do it by certified letter or hand deliver and have the landlord sign that they received it. But you can't play with the landlords, okay? You can't trust. You've got to document everything. And then you need to document your payments to the landlord as well. Don't rely on just, I gave the landlord cash. That's not going to work in court. You've got to have your receipts, and if your landlord doesn't want to give you receipts, you have Venmo, you have Cash App. Take a picture of yourself giving the landlord the rent, all right? But everything needs to be documented. Even if you have to send the landlord a text, I just want you to know that, following up, I just gave you $600 for your October's rent. Document everything. And also, when you have a mold or mildew situation, come into court and saying, Your Honor, this is a picture of the mold. There's mold all in the bathroom and he never did anything about it. No, that's not going to work. You've got to prove that it's mold. Pictures, the court cannot go by pictures. They cannot make that jump. They cannot speculate with you. Get a cheap mold test from Home Depot or Lowe's. It costs about $13 and $40 to analyze it. You'll get an email back with all the analytics, whether it's black mold, what type of mold it is. And now you've got documentation, again, that there's mold in the unit. And one step further, give your landlord a copy of that mold report. Because if the landlord does not have a copy of that report, you can't prove that the landlord would have the landlord would have done something. Again, they're going to go with the "I didn't know, Your Honor" defense, and then the court's going to ease up on them. But the moral of the story here is, in small claims court, this is what you're going to ask for. You're going to ask for that rent to be abated or reduced to reflect the condition of the premises. So if you're paying $1,000 for your unit and it's really worth $400 because of all the mold, because of the rats, the hole in the ceiling, now you have something to say to the court. Now you have a defense. Judge, this rent needs to be abated, and I'm asking that you reduce the rent to $300, to $400. And sometimes I've seen the judge even say, you pay nothing until the repairs are made, because you've been paying religiously for the last 8 months, and you've been enduring this for the last 12 months. So please, always pay the rent. If there's nothing else you take away from this video today, do not withhold the rent. That is not the way to go. All right? And again, like I said, I'm going to follow up with some legal defenses, because a lot of people have trouble with that. What is a good legal defense? So I'm going to follow up with that. And again, like and subscribe. I was going to say like and describe, but like and subscribe, all right? I want to keep giving you more content that you can use in your day-to-day life. Like and subscribe. And in the comments below, let me know if you've had some horror stories with your landlord, or just tell me some subjects you want me to talk about. Something that's really, relatable for a lot of people, because you'd be surprised. A lot of us are going through the same things. We're having the same experiences. And again, if the law is different in your area, just, Google it. You can ask me questions about it, and I'll get back to you. All right? So until next time, bye-bye.